come here for the negotiation session at 10 a.m.?
Oh, hi, yes. I've been expecting you.
Yeah.
Please come inside. I have
Okay,
to see.
thank you.
Okay, so how was your trip to our office today? I think there's a heavy downpour just now, and honestly, I thought you would be here a bit late, but it's great to have you here on time.
Yeah, me too actually. I'm glad I decided to come here a bit earlier, but thanks to the weather, I barely got here on time.
Oh, okay. So before we start, how do I address you?
My name is Hannah, so I guess you could just call me that. And how about you?
Oh, Chelsea or Miss Chelsea is just fine.
Okay. All right, Miss Chelsea. First and foremost, as a representative of my client, I would like to express our thanks to you and your client for agreeing to our proposal for negotiation in regard to the issue that is at hand between your client and mine.
Oh, you know what? Don't even mention it. On our side, we are also on the same page. That is, that if we can work out a reasonable agreement from this negotiation without having to go through the lengthy and pricey course of court proceedings, it would be a relief, and it is in the best interest of both of our clients.
Yes, exactly. I definitely agree with that, and especially considering the circumstances of both our client and also the subject matter at hand. So I think the first thing that we both need to establish is regarding the exact amount of debt that your client, that my client allegedly owes your client.
Okay. In my hands right now, these are the bank statements that have been given by my client in the previous client counseling session we have the other day. I would say my client did pay for the defendant's car service expenses, the same car workshop in the span of 3 years, starting from the year of 2021.
Okay.
Well, as always, I believe that we should listen to both parties since we are now negotiating to reach a settlement which works best in the interest of both of our clients.
Oh, I really am starting to get fond of you and your firm, Miss Chelsea.
Yes.
This is such a good approach as to settle a dispute through negotiation instead of court proceedings. For starters, I suggest that we both look at our bank statements that we got from our clients.
Sure. Okay. Let's see. Okay. I have right now the copies of my client's bank statements, which were dated at 15th of March 2021, 20th of April 2021, and also 25th of May 2022. These are the bank statements which specifically pointed out that my client did pay for your client's car expenses. And I was also informed by my client that the defendant, that your client had paid a portion of his debt totaling up to 4,000 ringgit. Honestly, my client would just like to claim the remaining 26,000 ringgit solely on the matter of the client's car expenses, and I saw the bank transaction receipts that had been sent to my client. Can you vouch validity of these receipts with your client's bank statements?
Okay, wait. Yes, indeed. My client did pay for the debt as claimed as your client. So what seems to be the issue? Why did your client opted to go for the extra mile by issuing an OD to my client? Because I thought that we are here to clear up the misunderstanding between your client and my client regarding the debt and the substantial amount that you have put onto us.
Okay. On my part, honestly, Miss Hannah, that's a bit odd because it seems that the facts that were presented to you by your client and my client to me is a bit different.
Okay.
Because my client claimed that your client had blocked her on WhatsApp to avoid himself from paying his debt.
I see. Well, I guess that is an important fact for us to consider before coming to a decision on this issue, I guess.
Okay, just to set the facts straight,
Mhm.
your client has blocked my client on WhatsApp, and that is mainly the reason why my client has decided to have the LOD issued to your client. So let's start from this point, shall we?
Okay. Alright then. The first matter that I would like to start is on the substantial amount that your client seeks to claim from my client. Bringing me back to the fact that I have also stated this in our reply to your letter of demand, that we must not forget that your client and also my client, the fact that both of them were in a romantic relationship. So, inferring from this fact, I think that it is clear that it is inevitable that both of them have spent some kind of amount of money on each other, especially considering the kind of relationship that they were in. I do not think that there's a legal recourse, especially in Malaysia, enabling any one person having been in a romantic relationship to be able to claim any of the expenses that have been spent on each other. But I've also been informed by my client that he thought that the payments that have been made by your client, specifically as has been said and provided by you earlier, like you told me earlier, the payments for the car repairs and such were made under his presumption that she was voluntarily making the said payments, like without any express intention for my client to having to make any repayments later on for the expenses that she spent on my client's car.
Okay, well, I understand what you're conveying, but firstly, considering that our client has made payments for the said expenses for your client numerous times, although she did not express it every time that she made those payments in regards to your client's car expenses, we have been informed that she had definitely made such payments with the intention that your client will repay her at a later time, and that she really had no intention of giving him this substantial amount of money over the years, regardless of the relationship at the time. In fact, we had also been informed by the client that your client and mine have definitely had the conversation from when they were still in a relationship, and it was indeed agreed between both of them that your client will repay her when he has the money to do so.
But I'm afraid that we cannot confirm this said agreement between the two, as we don't think that there's any conclusive evidence that actually says that my client will definitely repay those expenses.
Alright.
But so respectfully, I think that this argument is really a he said she said situation with no real evidence, and that that evidence that it really happened. So for us or your client to hold my client liable entirely based on this argument itself, I think would be an injustice towards him.
Well, while I agree that it is an injustice to solely depend on this fact alone, earlier in this session, you are aware that your client has in fact made repayments to the alleged debt by a client, right?
Yes, that's right. You're referring to the 4,000 ringgit that my client paid, right?
Yes, true. So you have to understand from our point of view now, we are of the opinion that regardless of whether or not the conversation between our two clients did happen, which stated that my client is expecting your client to pay for the expenses that she had paid, it clearly shows that the client had actually acknowledged that he indeed owed an amount of money to our client because of the some part of repayment he made to our client?
Well, sadly, we don't think the same as the said agreement that you said earlier had only merely been done through WhatsApp and between the two parties. And just because our client agreed to make these said monthly payments towards your client, doesn't constitute that our client acknowledges, expressly acknowledges the fact that he suddenly owes your client a substantial amount of 30,000 ringgit.
Okay, let's retrace back a bit of our steps because I believe you forgot that your client had already made part repayment to our client for the amount of 4,000 ringgit based on these bank transactions, and it was done so from the total of 30,000 ringgit. And this clearly shows that your client had actually acknowledged that he indeed owes the said amount of money to our client. We think that the moment your client stopped making the monthly payments, a cause for action arose against the client for his default in payment.
I see. But regardless of that, I'd like to also bring to your attention of the expenses that my client himself has spent on your client. Like, they've been in a romantic relationship, right? So are you aware that my client has been at the time of the relationship, my client has been giving your client a monthly allowance to your client consistently, like every month, and then 280 ringgit per month. I have the receipts here too. If you like to reconfirm the fact that you gave the 280 ringgit per month.
Okay, well, actually, this is new to me. My client did not point out this fact when we discussed this matter the other day, and it reconfirming the fact that you had just raised. I actually saw the transactions here. Can you please enlighten me more on the specific fact that you have raised just now?
Well, based on these copies of bank statements that I got from my client, it is evident that the financial expenses of this romantic relationship were supported by both parties, like both your client and my client, instead of like a one-sided effort like your client claims. But if anything, I say my client is right in the sense that the debt claim by your client should be lowered instead, because he also spent this amount of money.
I agree. Judging from this mounting evidence, I would say, are you suggesting that we set off the amount that your client owes towards a client with his said monthly expenses? How much would that amount to exactly?
Right. Well, based on our calculations, it would total up to 10,080 ringgit, or we calculated over here. And so, if your client wish to claim for the 26,000 that extra for the expenses that she paid for our client's car, then we'd like to set off the amount of that 26,000 ringgit with this 10,080 ringgit, which would lower the amount owed by our client to yours to about 15,920 ringgit.
Okay. Miss Hannah, I note that you said your client has made this monthly payment for our client's monthly allowance. Am I right?
Yep, you're right. That's right.
Okay, again, respectfully, comparing your client's claim for the monthly expense for allowance and our client's claim for expenses spent on your client's car, specifically the cost of repairs, I personally think that that's an unfair comparison, don't you think?
And why is that, Miss Chelsea? Because I am of the opinion that both our clients are entitled to claim for each of our claims respectively, especially since both our clients were able to pinpoint specifically on the type and reason they have had to spend the set amount that both claims on each other.
Okay. Well, from my point of view, as opposed to the claims that have been made by my client, the claim that your client is trying to set it off with our client, with the expenses that your client had spent, especially since you used the term allowance, I think it shows that it is an expense that have been voluntarily spent on your client's side, which means it's a gift.
Okay, but I think that since my client was able to pinpoint the exact amount and exactly why he has spent on your client that amount of money, then in our case, the monthly allowance of 280 million, then he too should be able to make a claim against your client for the amount having total up to 10,080 million.
Okay. Miss Hannah, I think it is important for us to differentiate between having lent an amount of money and having spent or gifted a certain amount of money. I think in my client's argument, it is clear that she said monthly allowance is an amount of money gifted to our client rather than an amount of money that is lent to our client. As opposed to the expenses that my client has spent on your client's car expenses, it is typically an expense that is not usually occurring in a romantic relationship, and more so since the amount of money that my client had spent on your client is also unreasonable if it is to be considered as a gift, since they are not husbands and wife and technically they do not have tie to each other at all, legally speaking.
Alright, I see your point, but so what are you suggesting for us right now, that we consider the allowances that my client had given to your client as a gift?
Okay, let's take a look here. I suggest we both look through the bank statements of our own client and point out if there are any other hidden expenses that should be taken into consideration, because we're trying to pinpoint the exact amount of money that your client should pay. Okay, I mean, who knows, after looking through all of this, the client might have to pay lower. My client planned.
So it's about
Miss Hannah, I can see that from my client's bank statement that my client had done 12 bank transactions, transferring an amount of money consisting 750 ringgit to a client in a span of 3 years. These transactions have car installment as the reference put forward by my client. Can you reconfirm with the bank statements of the client, please?
Okay. Give me a moment. Oh, you're right. There are indeed the same records in my client's bank statements as well. I guess I would have to tell him about this recent development to let my client know that the claim is no longer just 26K.
Okay. Right, I understand, and I like how we think the same thing. Because honestly, my client deserves to get the exact amount of reimbursement as the amount of money that she had spent on your client. So the recent discovery, as we both agreed, would have meant that the claim of my client would be 35,000 ringgit as of now.
Alright.
So with all this info, it is a clear-cut case that your client should pay the debt towards our client. So how do you propose your client to pay off this debt?
Okay, actually, especially considering the substantial amount of the debt between your client and my client, and also the circumstances of my client, which at the moment, I think you and your client should also know that my client actually lost his job just last month, and is currently just relying on the savings that he already had. Yeah. So right now he's also doing like Grab food delivery things, but that's all he's relying on for now. So with that information, I'd like to propose that we construct a monthly payment plan for my client to be able to make payments to your client.
Okay. I actually sympathize with the client's circumstances, and I understand. But if we were to agree on the suggested payment plan, my client would be waiting for reimbursement to be settled for quite a while. That is, if there's no range of limit on how low your client would pay off his debt in every month. So how much per month would you like to propose the client pay towards my client, like the lowest?
Me and my client, we're thinking about I don't know how around 200 ringgit per month. If that's okay with you and your client.
Okay. Pardon me for being a bit harsh, but I think that 200 ringgit per month is a bit low. Like I said earlier, if your client is only paying 200 ringgit per month, it will still take forever for my client to be able to receive the amount of reimbursement in full. May I suggest 400 ringgit per month instead?
Actually, 400 ringgit might be a bit out of reach for my client right now, especially considering his circumstances at the moment.
Alright.
How about 300 ringgit instead? Like, the middle ground should be perfect, right?
300 ringgit, huh? Okay. Hold on. I guess 300 ringgit wouldn't be too low for my client now, since from this info, she has a stable job as of now. So, why don't we put this payment plan in the agreement so that our client may perform their contractual obligations with a binding document?
Alright, noted, Miss Chelsea. I'll be sure to put the payment plan all in writing and get back to you for both my client and also your client to put down your signatures and to acknowledge to the agreement.
Okay, well, one more thing. If, let's say, a binding document is would be beneficial for my client, but it would be a disadvantage for your client, because if he happens to default payment, then you would have no choice but to proceed legal proceeding.
Alright, I'll be sure to include that, and of course I would put that into the agreement that we will later put in writing, and also inform my client of that importance. So I guess that's all, right?
Oh yes, that's it. Thank you very much for coming this morning.
Okay, thank you. That's all. Thank you, Miss Chelsea.
Okay.